Hi, welcome back. Today we are going to discuss about layoff with respect to Industrial Disputes Act 1947. Section 2 subclause KKK, that is section 2 subclause triple K of the Industrial Disputes Act 1947 defines layoff. Layoff is defined as the failure, refusal, or inability on the part of the employer to give employment to a workman whose name is found in the muster roll. The reasons are A. Shortage of coal, power, raw materials, or accumulation of stock or breakdown of machinery or natural calamity. B. Any other reason. This phrase must be interpreted by adopting the ageism generis rule of interpretation. So, we have two categories. One is shortage of coal, power, raw materials, or accumulation of stock or breakdown of machinery or natural calamity. And then it also says that any other reason. So, the phrase any other reason is to be interpreted by using ageism generis rule of interpretation. Now, layoff and lockout. Layoff generally occurs in a continuous business, whereas lockout is closure of business for the time being. In lockout, it is adopted by the employer to coerce the workman, whereas in layoff, the employer expresses his inability to provide employment due to certain reasons. Lockout will affect the entire industry, unlike a layoff. In layoff, compensation must be paid by the employer, unlike in the case of lockout. Lockout is resorted to by the employer as a weapon against the collective bargaining, and it involves an element of ill will or malice, while layoff is actuated by trade reasons. For lockout, penalty is prescribed where there is no penalty for layoff. Layoff is temporary deprivation of work for workmen whose names are recorded on the muster rolls of the industrial establishment. The workmen are not provided with the work due to reasons beyond the control of the employer. The employer has no intention to refuse work but is compelled to do so because of reasons beyond his control. In Management of Kayarbetal Estate Kotagiri versus Rajamanikam 1960. In Management of Kayarbetal Estate Kotagiri versus Rajamanikam 1960, the Supreme Court held that the layoff takes place for one or more of the reasons specified in the definition of layoff under section 2 KKK of the Act. It may be due to shortage of coal, shortage of power, shortage of raw materials, or accumulation of stocks, breakdown of machinery, or any other reason. The workman concerned should not have been retrenched. If a worker has been retrenched due to shortage of work as a surplus labor, he cannot be laid off because he ceases to be an employee. The name of the workman laid off should be on the muster rolls of the industrial establishment and he presents himself for work at the establishment at the time appointed for the purpose during normal working hours on any day and is not given employment by the employer within 2 hours of his so presenting himself. Then he shall be deemed to have been laid off for that day within the meaning of this clause. Now, if the workman, instead of being given an employment at the commencement of any shift for any day, is asked to present himself for the purpose during the second half of the shift for the day and is given employment, then he shall be deemed to have been laid off only for one half of that day. If he is not given any such employment, even after so presenting himself, he shall not be deemed to have been laid off for the second half of the shift for the day and shall be entitled to full basic wages and diurnal allowance for that part of the day. So, a layoff can be for a whole day or a half day, and if the employee presents himself as demanded by the employer for the second half of the shift and even then employment was not given, then it will be considered as a whole day of layoff and dearness allowance and basic wages will be given for that day. Now, Section 25C, Section 25 capital C provides that whenever a workman other than a badli workman or a casual workman whose name is borne on the muster rolls of an industrial establishment and who has completed not less than 1 year of continuous service under an employer is laid off, whether continuously or intermittently, he shall be paid by the employer for all days during which he is laid off except for such weekly holidays. So, during layoff, he shall be given payment for all days except for such weekly holidays as may intervene, compensation which shall be equal to 50% of the total basic wages and dearness allowance that would have been payable to him had he been not so laid off. So what he was entitled if he was not laid off, so that basic wages, dearness allowance, etc., the aggregate of it, 50% of that aggregate will be the compensation. Now, provided that if during any period of 12 months a workman is laid off for more than 45 days, no such compensation shall be payable in respect of any period of the layoff after the expiry of the first 45 days if there is an agreement to that effect between the workman and the employer. Provided further that it shall be lawful for the employer falling within the foregoing proviso to retrench the workman in accordance with the provisions contained in the section 25F at any time after the expiry of the first 45 days of the layoff, and when he does so, any compensation paid to the workman for having been laid off during the preceding 12 months may be set off against the compensation payable for retrenchment. Badli workman means a workman who is employed in an industrial establishment in place of another workman whose name is borne on the muster rolls of the establishment, but shall cease to be regarded as such for the purpose of this section if he has completed 1 year of continuous service in the establishment. So, even if it is a badli workman, if he has completed 1 year, then he will be considered under this section. The compensation for layoff is governed by the provisions of Chapter 5 capital A. The compensation for layoff is governed by the provisions of Chapter 5 capital A. In Tata Nagar Foundry Company Limited versus their workman, 1962. In Tata Nagar Foundry Company Limited versus their workman, 1962, the Supreme Court held that if the layoff is justified and it satisfies the requirements of the definition under Section 2 KKK, the only relief to which workmen laid off are entitled is the statutory relief prescribed by Section 25 capital C. If the layoff is malified in the sense that the employer has deliberately and maliciously brought about a situation where layoff becomes necessary, then it would not be a layoff which is justified under Section 2 subclause KKK, and the relief provided to the laid-off workmen under Section 25C would not be only relief to which they are entitled. In Workmen of Due Tea Estate versus the Management. In Workmen of Due Tea Estate versus their management, the Supreme Court held that Section 25C, which recognizes the right of workmen who are laid off for compensation, provides that whenever a workman therein specified has been laid off, he shall be paid by the employer for whole of the period of layoff except for such weekly holidays as may intervene, compensation at the rate prescribed by the section. Now, when he is not entitled to layoff compensation, that is discussed in Section 25 capital E. Section 25 capital E provides that the workman laid off is not entitled to layoff compensation in the following condition. That is, three conditions are given. The first one, if he refuses to accept any alternative employment in the same establishment from which he has been laid off, or in any other establishment belonging to the same employer situated within the radius of 5 miles from the establishment to which he belongs, if in the opinion of the employer such alternative employment does not call for any special skill or previous experience and can be done by the workman, provided that the wages which would normally have been paid to the workman are offered for the alternative employment also. So that is the first condition. So if a person refuses such an offer, he is not entitled for layoff compensation. Now the second condition is, if he does not present himself for work at the establishment at the appointed time during normal working hours at least once a day. And the third condition, if such laying off is due to strike or slowing down of production on the part of the workman in another part of the establishment. So in these three conditions, particular person is not entitled for layoff compensation. The section provides that that is 25E, provides that if the workman laid off is offered similar or like employment and he refuses to do that, then he is not entitled for any compensation under section 25C. So once again, section 25E provides that if a workman being laid off is offered similar or like employment and he refuses to do that, then he is not entitled for any compensation under section 25 capital C. The expression any alternative employment in section 25 capital E of the Industrial Disputes Act must mean any other similar or like or equivalent employment to the original job. It does not mean that a variety of jobs be offered. Offer of one alternative job must be considered enough, but that job must be like or similar to the original job from which the workman concerned were laid off. The clause that can be done by the workman is very noteworthy in the condition of section 25 capital E and means not only physical capability but also its acceptability on the part of the workman. The Supreme Court in Industrial Employees Union Kanpur versus J.K. Cotton Spinning and Weaving Mills Company, that is 1956. The Supreme Court in Industrial Employees Union Kanpur versus J.K. Cotton Spinning and Weaving Mills Company, 1956, held that offer of the job of coolie to a skilled workman cannot amount to offer of an alternative job. So that is with the end of this session where we discussed about layoff and who is not entitled and who is entitled, about the compensation and how different types of layoff, that is for full day, half day layoff. So that is what we discussed here. Thank you for listening. Thank you for your support. Like, comment and subscribe. Don't forget to click that bell icon so that you get an update when I upload my next podcast or a video. Have a nice day. Take care.